Being a landlord has its fair share of risk. Your tenant could quit paying rent. They could thrash the property. They might leave it a complete mess, and who knows, you might even have to do an eviction. One tool that a landlord has to help protect them from at least some of that risk is the security deposit. Now, every state has its own set of laws and rules affecting how security deposits are handled. California certainly has their fair share. So, in this blog, I will attempt to answer some of the more common questions we get regarding security deposits. A common question is, what's the maximum security deposit we can charge? Well, in California, the maximum security deposit a landlord can charge is 2 months' rent for an unfurnished unit. That's unless the tenant is active military, then it's 1 month rent. And for a furnished unit, it's 3 months rent, and then it's only 2 months for active military. Now, that being said, that's the maximum. There's no minimum, and I find here in Southern California anyways, most landlords charge the equivalent of 1 month's rent for their security deposit. And a trend we're seeing with some of the bigger buildings, some of the larger sort of luxury complexes, they even go less than that as a way to be more competitive, get their places rented quicker, and probably get a little more monthly rent because they ask for less up front. So that's a little tip on security deposit. Next, landlords sometimes ask, can they charge a non-refundable security deposit? Well, the answer in California is no, you can't. Security deposits are refundable. Now, when the tenant moves out, there's a process for charging for damages, and of course, you can charge a cleaning fee. We get landlords that ask us how a security deposit is to be held here in the state of California. You see, many states have very specific rules and laws dictating how a security deposit is to be held. Well, surprise, here in California, we don't have any laws that state how it's to be held. Also, sometimes people ask, do tenants have the right to be notified of receipt of the security deposit? Well, technically, no. I will say, though, to any landlord, you should be documenting everything. And by all means, the security deposit should be named off in the lease agreement. So you may ask, what reasons are there that a landlord can make deductions and hold back part of the security deposit? The most common ones are non-payment of rent, excessive damage to the property, and cleaning cost. But you can't hold back for ordinary wear and tear. You may also ask, do tenants have the right to a pre-move-out inspection in the state of California? And in fact, you're right. The tenants do have the right to a pre-move-out inspection in the state of California. So the landlord is required to offer a pre-move-out inspection to the tenants, and it must be no sooner than 2 weeks prior to their move-out. You also have to give them at least 48 hours notice before that. And this is something the tenant does not have to accept. They just have to be offered the move-out inspection. And then after that inspection, you let them know of any sort of damages or things that they would then have the opportunity to fix. And that's the real purpose of the pre-move-out inspection, is to kind of reduce the chance of any surprises for the tenant. So some landlords may ask, can you require an additional security deposit to accommodate a tenant with a disability? No, you cannot. In fact, the tenant can make those adjustments and modifications, and then on their own, with their own expense, and then they have to, at their expense, put it back to how it was. But You absolutely do not have a right as a landlord to charge anybody with a disability extra for the modifications to accommodate them. So you may ask, how long do you have to return the tenant's security deposit? Well, you have exactly 21 days. That's the max you can take. At that time, you need to send back an accounting that includes what the security deposit amount was. You itemize the deductions, and you want to include, of course, any remaining amount left. So you may ask, what happens to the security deposit when the property changes hands? Well, there's one of two options. The first is that the security deposits are transferred over to the new owner of the property. And the second is the security deposit is returned to the tenants. Although the second option may not work for the buyer of the property. They would not want to have to go and get all the security deposits themselves again. So typically they get transferred over to the new owner. Now, there's something called a tenant estoppel certificate, which is it's a piece of paper that everybody signs and agrees on all those amounts. And that really cuts down on the amount of confusion for everybody during real estate transactions regarding security deposits. Bottom line, there's a lot involved with laws regarding security deposits, especially in the state of California. And let's not forget, these laws are always changing. Plus, there's more restrictive county and city laws that are often involved as well. So please, let's not confuse this with us giving you legal advice. I highly advise you consult with an actual attorney, preferably one licensed in the state of California, specializing in real estate law when you want to find out about the laws. But if you'd like to find out more about property management and real estate services and things of that nature, we'd be more than happy to talk with you here at the Mike Dunfee Group. If there's another subject you'd like us to cover, there's some other specific questions, please feel free to make comments below. Thanks for listening, and please feel free to like and subscribe, and we'll see you.